Good afternoon, everyone. Welcome to the latest of Field Fisher's privacy webinar series. My name is Renzo Marchini, and I am a partner in the privacy practice in London. Thank you so much for joining us. Today's webinar is called EU Privacy Hot Topics for Farmers and CROs. Data is, of course, key to the development of new drugs and raises plenty of issues which are unique to the sector, especially in the context of clinical trials where there are many stakeholders, the sponsor, the CROs, the sites, but also not only data protection regulators, but ethics committees. Since GDPR came into force 2.5 years ago, many participants in trials have revised their processes, but we still do see a lot of documentation and practices that do not reflect the changes that arose as a result of GDPR. We're helping many clients undertake their responsibilities here and thought it would be useful to pick out some of the common themes and topics we are seeing and advising on. I'm delighted to be joined by two colleagues who work a lot with our life sciences clients and are part of our health data group. Kirsten Whitfield, a director in our team, and Michael Brown, a senior associate. I will introduce GDPR, although many of you, of course, are very familiar with it, and then Kirsten and Michael will do a tag team through the various hot topics. We will finish within the hour, that is 5 o'clock in London. Before we come on to the substance of a few points about us and also a few housekeeping points about the webinar. For those of you that do not already know us, Field Fisher is an international law firm with offices across Europe, in Silicon Valley and in China. Our privacy team works across all of those offices. We are a collaborative team providing strategic and actionable privacy solutions. Turning to housekeeping, please do ask us questions using the question function on your screen. We've left time for it. We'll be able to take some as we go along, and we'll have some time at the end as well. If we do run out of time, we will respond to questions posed in writing. And next week, you will receive a copy of our slides and indeed even a recording. So do not feel as if you have to scribble everything down as we go along. Do please also subscribe to our blog, which has a regular set of posts on topical issues, and do keep an eye out also for more of the webinars over the coming weeks and months. So today's structure of the webinar is on your screen now. I'll introduce GDPR and do a little recap of some of the key points. I'll be brief on that because, of course, most of you will be very familiar with it. Then I'll hand over to Kirsten, who will deal with a typical issue in clinical trials, working out the lawful basis for processing. Michael will talk about the distinction between controllers and processors and how characterizations differ and are important to get right in various jurisdictions. Back to Kirsten on handling data subject requests, which of course happens in all sectors, but does have its own particular challenges in the life sciences clinical trials world. And then back to Michael on international transfers and very topically, the impact of the recent judgment in Schrems 2. And lastly, Kirsten will talk us about security and certain recent enforcement trends. So with no further ado, I'll carry on with a brief recap of GDPR. But before doing so, a quick word on the dreaded B word, Brexit. The three of us today are UK lawyers, and of course, the UK is now out of the EU, and come the end of this year, will no longer be part of the single market, and EU law will no longer apply in the UK, but the UK government has legislated so that a lot of laws will carry over and be grandfathered into domestic law as if they were UK statutes. So what is now the EU GDPR will become, with certain necessary textual changes, the UK GDPR. But for present purposes and the present audience, the substance of the legal obligations will be exactly the same. So no real changes as a result of the end of the Brexit transition period. Now, GDPR, the UK version or the EU version, doesn't just apply to UK, EEA or UK companies, for short European companies, other companies are also in scope, and they might be in scope in one of either two limbs. First of all, the non-European company may be established in Europe, even though it doesn't have an office, branch, or corporate entity here. And there was a case a few years ago called the Google Spain case at the Court of Justice of the European Union, which illustrated this, where Google Inc. was found to be subject to GDPR because it had a sales affiliate in Spain. So a non-European sponsor in a clinical trial might be subject to GDPR on that ground. It might also be subject to GDPR on the alternative ground, which is, for those of you that know GDPR, Article 3.2, in that there might be an offering of goods and services into Europe, or there might be the monitoring of behaviour of individuals in Europe, and both of those are possibly applicable or likely to be applicable to the trialling of drugs in sites in Europe if the controller is outside of Europe. In terms of actually substantive law, the key principles in GDPR in your slide right now, and they're key principles which were under the old law as well, and indeed are reflected in many laws in many jurisdictions around the world. Concept of fairness and lawfulness, and Kirsten will talk about legal bases later. Purpose limitation, the idea that when you collect data, you can only use it for certain purposes that you've specified, and other purposes which are not incompatible with those purposes. Now, there is a privilege there for scientific research, which is also potentially applicable to a lot of data that's been collected in the context of clinical trials. Obligations of data minimization, you mustn't actually collect more data than you actually need for your specified purposes. Obligation to keep data accurate. Data retention obligations, you mustn't keep data longer than what is necessary. And of course, in this regulated area, there will be a whole body of clinical law, clinical regulatory law, which specifies retention of data in terms of adverse events, in terms of results of the trial, and so on, which will bite into that particular obligation, and an obligation on security. One of the key changes when GDPR came into existence was the bringing into the scope of substantive data protection law of processors. And so the distinction between controller and processors, although was previously critical, processors being out of scope pre-GDPR, now in scope, has become less important, but still important because it does determine what sort of documentation you need. Michael will be coming back to that point. And then lastly, on my quick whiz through in relation to GDPR, is the concept of accountability that I want to mention. The idea that GDPR sets out that you must not only be seen to just comply with law, but you must be able to demonstrate your compliance with law. We had a webinar on this topic about a month or so ago, so those of you that are interested, please do get in touch and we'll point you towards a recording if you missed it. Certain aspects of accountability up in your screen, the need for a formal data protection officer in some circumstances, when and in the clinical trials world, medical data, typically all operators will need a DPO because there will be large-scale processing of special category data. The need to have policy documents and good governance in relation to data, and the need to have formal data protection impact assessments, potentially, particularly in relation, for example, into collecting data as part of a trial. The triggers will inevitably be will apply in that particular context. So apologies, that was a really rush through some of the key features of GDPR, but now I'll hand over to Kirsten to talk about one particular aspect, lawful bases.
Thanks, Renzo. So kicking off with our first hot topic number 1 of 5, we wanted to give you some insights on lawful basis for processing based on our experience of dealing with sort of helping with clinical trials and privacy aspects and other sorts of health data processing. Now, the really big item to mention here is that it is very common to ask for consent to process patient data across Europe, and historically that has been the case, and that's continued into GDPR. But one of the issues that was brought in by the GDPR is that they actually raised the bar in terms of obtaining that consent to process patient data or health data. And that consent, it's a different consent to the consent that you might seek in say, a clinical trial, where you get consent via the ICF for someone to take part in the clinical trial. So this is a consent to actually process their personal data, and does need to be looked at a bit differently. Now, the issue with consent, and I'll come back to this a few times in my hot topics, but the big issue with consent is that it could potentially be invalid because the person giving that consent might not actually have a genuine choice. And I mentioned that the GDPR raised the bar, and now built into the GDPR is that it must be a freely given consent. So this is an issue around asking for consent to be mindful of. Now, consent isn't actually the only GDPR lawful basis for processing. It's just one of the bases on which you can process personal data. So the basis for processing personal data, or lawful basis as they're called, are set out in Article 6 if it's not special category personal data, and that will include health data. And in Article 9 if it's special category personal data. So this is the key one for health data. We've moved on to the next slide, please, Renzo. Now, I thought it might be helpful if we just give a little recap of what all these lawful bases for processing are that might stand as alternatives to consent. So top of the list, you've got consent, but I've got it in red there because, as I said, it can be problematic, and I'm going to go into some more detail on that later. Another lawful basis for processing personal data, and this is not special category personal data, is if it's necessary to perform a contract with the data subject, or to take steps requested by the data subject before you enter into that contract. Usually that won't be relevant to health data processing. One that really could be relevant though, certainly in clinical trials, for example, is the lawful basis that it's necessary to comply with a legal obligation that the controller is subject to. So you may have regulatory requirements to document certain information as part of a clinical trial, and then you could rely on the legal obligation for processing. Another one that might be relevant for health data is if it's necessary to protect the vital interests of the data subject or another. Although I've put that in amber there because it's not quite as easy to rely on that one. Really what they mean there is vital to the health, safety, life of an individual. So say in a clinical trial case again, that typically wouldn't be one that you would rely on. And another lawful basis is that it's necessary for a task carried out in the public interest or to exercise the official authority of a controller. Now, certainly, quite often health data processing, certainly in the clinical trials perspective, you could quite rightly say that that is in the public interest. So that's an option there. And then finally, again, Article 6, the legitimate interest of controller or third party, except where overridden by interest or fundamental rights and freedoms of the data subject. So basically what that one is if you as a controller have a legitimate interest in processing the data, so clinical trial or data analytics, health data analytics, whatever, you've got a good reason for doing it, you could rely on this lawful basis for processing. But what you do also need to do is a balancing act when relying on this one. So you weigh up the controller's interests against the rights and interests of the data subject. So if it's overly privacy intrusive or somehow encroaches on other rights or freedoms that they might have, then you might find you can't rely on that particular lawful basis. So on to the next slide. So let's just have a look at the special category personal data lawful basis then. So as I said, this is in Article 9. Consent, again, it's in there, but I've flagged it in red as the difficult one. Another lawful basis you might be able to rely on is that it's necessary to carry out obligations and exercise specific rights. Oh, thank you. Specific rights of the controller or of the data subject in the field of employment, social security, and social protection law. So that one probably is less helpful from a health data perspective processing, unless, say, you're an employer and you have to keep sickness records, for example. It's necessary to protect the vital interest of the data subject or another, so that's the same one as in for Article 6. It's necessary for legitimate interest of a foundation, association, or not-for-profit, and then with these very specific aims that are listed there, that usually won't apply to health data processing. Where the data has been made public by the data subject themselves, so I mean that usually won't apply again. That really applies where, say, you know, on a social media platform, a data subject has they've published data about themselves and made it available on the internet. And then finally, here on this slide, necessary for establishment, exercise, or defence of legal claims, or whenever courts act in a judicial capacity. So that one could be relevant, and I flagged it there in amber. It might not be, but say if you had in a clinical trial, you had an adverse event, and you might have a legal claim, and you might need to rely on personal data, and this Article 9 basis for processing would stand you in good stead. So thank you. On to the next slide. So now here are the last three that I wanted to talk to you about, and you'll see that they're all in green. So these are lawful bases that are probably more relevant to health data processing, certainly for clinical trials. So firstly, necessary for reasons of substantial public interest. So quite often health data processing, certainly in a clinical trial perspective, you could rely on this as a basis for processing. Another one you could potentially rely on is that it's necessary for the purpose of preventative or occupational medicine, assessment of working capacity of employees, medical diagnosis, provision of health or social care or treatments, managing health or social care systems and services, or pursuant to the contract with a health professional, but they would need to be subject to professional secrecy. So that's, say, you know, doctors, for example. So that is a potential one that could often apply. And then finally, it's necessary for archiving in the public interest, scientific or historical research or statistical purposes. So if you've carried out data analytics or you've carried out a trial and you need to archive that data, then you could potentially rely on that lawful basis for processing of your health data. Okay, thank you. Right. Now, the European Data Protection Board have issued some guidance or recommendations when it comes to clinical trials as to what lawful basis they think the controller ought to be relying on when processing personal data. And just in a nutshell, I've summarized it here on the slide for you. Essentially what they're saying is that if it's things like safety reporting, archiving files, which you're required to do, disclosures to national competent authorities that you have to do, for non-special category personal data, they've said here, rely on Article 6(1)(c), which is the legal obligation one. And for special category personal data, they've said you ought to rely on the public interest in the area of public health basis for processing. For all other processing, they've said for non-special category personal data, you've got a number of options. So it could be a task carried out in the public interest could be your basis. It could be legitimate interests. And as I mentioned earlier, you have to do that balancing act between your interests and the data subjects. They also said it could be consent, but essentially they're saying do that as an absolute last resort, rely on the other ones first. If it's health data, then the lawful basis they're recommending are public interest in the area of public health, or the archiving purposes in the public interest, etc., which I mentioned earlier. And again, you could rely on consent, but that's the basis of last resort. If we move on to the next slide. Now, despite the fact that the GDPR was intended to harmonise data protection laws across Europe, and we had this guidance from the EDPB, we still don't actually have any consistency. What's actually happening is that you've got regulators like the UK, the data protection regulator here, their recommendations are broadly in line with the EDPB, or European Data Protection Board, in terms of lawful basis for processing. In France, if you rely on a CNIL certification for your clinical trial, then again, the lawful basis you can rely on are broadly in line with the EDPB. But they're also saying, alternatively, you could rely on consent. So they're sort of in between. And then you've got other countries, and I've given you just a few examples here, where the guidance there is, no, actually, you should be relying on consent. So we've got this inconsistent patchwork across Europe, which isn't helpful, particularly in multi-jurisdictional clinical trials. Now, just to give you a few practical considerations in terms of lawful basis, and in particular in relation to your privacy notices. Now, the fact that you may have to rely on different lawful basis depending on what country you are carrying out a trial in, you will potentially also then need to be reflecting different things in your privacy notices. So your privacy notice needs to be tailored to the country. Another issue to watch out for is that for clinical trials, separation of the privacy notice from the ICF is a better option for the purpose of GDPR compliance in terms of being transparent and it being absolutely clear to individuals, you know, what your personal data processing activities are. However, that said, we still have a patchwork across Europe of different approaches being taken, and in some countries, actually, you still see the ICF and privacy notices being put together. You know, other countries, they're more going down the line of separating them out. So, you know, it'd be a matter of looking at local guidances and local practices. Either way, regardless of which approach you take, you do need to make sure that you're very careful about your drafting of your privacy notice. So it's really clear which sections are your privacy notice and it's intelligible to the reader. So thank you, Renzo. I shall hand over to Michael.
Thanks, Kirsten, and good afternoon, everyone. So in Hot Topic 2, I'll address the controller and processor roles performed by organisations in two separate areas: clinical trials and market research projects. And crucially, I'll highlight what these roles mean for pharmas and CROs in terms of your practical compliance. So it can be complex to assess the roles correctly for various reasons. These include that there's no one-size-fits-all approach to a clinical trial or a market research project, and indeed the processing activities often tend to be very trial or project specific. Also, at least in relation to clinical trials, the legal position on data protection roles does vary between EU member states. So before getting into the meat of the topic, I'll pick out some pertinent points on the concepts of controller, joint controller and processor. I'll also do the same in relation to personal data, anonymous data, pseudonymous data and special category data. Appreciate some attendees of this webinar might be very well versed in these concepts, and so forgive me if it seems like I'm going through Data Protection 101. However, often what we see in our practice when advising on clinical trials and market research is confusion or friction between parties simply due to misunderstanding the fundamentals. And that's especially the case in multi-jurisdictional projects and or when you're dealing with an unsophisticated trial site or market research agency. So the GDPR categorizes organizations that process personal data as being a controller or a processor. So in simple terms, the controller can be thought of as the entity that determines why and how personal data is processed, whereas the processor simply provides outsourced data processing services on behalf of the controller. It does not exercise any autonomy in how or why the data is processed. The term joint controller isn't actually defined under the GDPR, but refers to where two or more controllers jointly determine the purposes and means of the processing of the data. So the need to distinguish data processing roles is obviously important to understand legal requirements, liabilities, and the nuts and bolts of compliance obligations. So do you need Article 28 GDPR contractual terms with a clinical trial site? Who is providing privacy notices to trial or market research participants? Are the pharma company and market research agency able to use the data for their own purposes? Those kind of questions. In addition, the risk exposure is high in a pharma context, where you're processing potentially large volumes of special category data, and indeed Kirsten will talk about security and enforcement later in the webinar, hence the need to be on a firm footing re data protection rules. So that's a brief canter through the roles and why they matter. Now on to the data itself. So as we know, the GDPR protects personal data. Data which is anonymous falls outside the scope of the law and therefore can be processed without restriction. GDPR defines personal data very broadly, encompasses obviously personal information, like name, contact details, and data which is less obviously personal, ID numbers and location data. Anonymous data is not explicitly defined in the GDPR, and in practice, European regulators have given very conservative guidance on anonymization such that it's difficult to achieve. One method of truly anonymizing data is via aggregation, which renders it impossible to single out an individual from the data set. And the UK ICO has provided anonymization code of practice, which sets out some aggregation techniques, so worth checking out in the event you have concerns about techniques deployed within your organization or by other parties on data sets. Pseudonymous data, the GDPR provides quite a wordy definition for this concept, but in layperson's terms, it's a technique that replaces or removes information in a data set that identifies an individual. Crucially, it's still considered personal data under GDPR and is very common in life sciences activities. Pseudonymous data is often referred to as coded data or linked data. And final category of data, so special category of personal data. This is a subset which is considered to be more sensitive than ordinary personal data. Includes the likes of health information, genetic information, biometric data, and subject to more stringent requirements. Much of the personal data processed in clinical trials and market research projects will obviously be special category and includes health information like medical history, experiences, side effects from a particular product. Could you move to the next slide, please, Renzo? So as Renzo mentioned at the outset, there are four main entities or groups of entities involved in a clinical trial. One, the sponsor of the trial, so more often than not a pharmaceutical or therapeutics company. Two, clinical research organization, which manages and facilitates the trial. Three, the site, which is a hospital, clinic, healthcare setting where the trial takes place. And four, an ethics committee, institutional review board, or other bodies which approve, review, and monitor the trial. So in the course of their activities, these organizations will process personal data of patients trialing the drug, as well as healthcare professionals managing the trial. And there's a bit of complexity there because sometimes the parties might be performing different roles in respect of the patient data and the HCP data. So for instance, a site in Belgium could be a processor for the patient data on behalf of the sponsor as a controller, but the site itself could be, and likely to be, a controller for their own HCP's data. So in the table in the slide, we've tried to set out the typical processing roles. First and foremost, sponsor will be acting as a controller. That's usually kind of non-controversial. CRO will likely be a processor. And then this is where it gets slightly tricky. So the role of the site varies on a country by country basis. So in the UK, local requirements and guidance interpret the site to be an independent controller. In the Netherlands, local guidance, I think it's from the CCMO, so Central Committee on Research involving human subjects, interprets the site actually to be a joint controller with the sponsor. And then local guidance in France specify the site to be a processor. So what this means is where you have a multi-jurisdictional trial, you'll need to check the position locally. Won't always be controller, processor, or joint controller across the board, and you may end up having different positions, which can lead to compliance complexity, especially to a point Kirsten's mentioned earlier, where you're relying on different lawful basis in each country. Also in some countries, you need to have the CRO as a party to the data protection terms with the clinical trial site. So there's that additional layer of complexity as well, where you might have a tripartite agreement between the sponsor, the site, and the CRO. So query is a kind of general question whether it's truly feasible to have a kind of fully harmonized uniform data protection compliance program for clinical trials. But I'll leave that one as one for all of us to ponder. So what does that mean?
Sorry,
Yes.
Michael, to interrupt, but we begin to get a couple of questions actually. First off, why is the sponsor a controller if it's only getting key coded data?
So for a variety of reasons, so the project itself is instigated on the basis of the sponsor's actions. So it's determining that it'd like to run the trial. So it's determining why the data is being processed and how it's processed. So it's giving some kind of general instructions to the site. So there's kind of controller behavior there. And I think maybe one of the points of the questions is, okay, the sponsor doesn't actually have access to the uncoded or unlinked data, but it would still be considered to be pseudonymous data and therefore subject to the GDPR. So simply by virtue of that coded data being in the hands of the site and the CRO, the sponsor is acting as a controller. So happy to provide a bit more detail on that, but hopefully that answers that question. Was there another question, Renzo? Or
no, there are some more, but let's carry on for now, and we'll pick them up at the end.
Yeah, and apologies if it seems as though I'm cantering, there's a fair amount to cover, but hopefully all kind of useful information. So what do these data protection roles mean for the organizations in practice? So for pharmas and CROs, you need to make sure that you have the right data protection terms in place for the countries and scope. Under the GDPR, remember, there's no requirement to have controller-to-controller terms, but probably good practice to do so, especially given the nature of the arrangement, health data being processed, and also the need to implement a mechanism for exporting data from Europe. Also bear in mind that some countries have template terms, which are mandatory, but our experience is they don't necessarily cover all the requirements, and good practice provisions around, say, cooperation, data subject rights, and so might need to be bolstered. And then also parties need to agree who's providing notice and obtaining consent, since, as alluded to in the question, the sponsor won't necessarily have or won't have a direct relationship with the patient and the HCP. So we often see template privacy notices and consents as appendices to contracts, or at least rules on what these notices and consents should contain. And these do differ between member states. So again, call to be made on whether to take some risk with a harmonized, kind of more pragmatic approach, or go for a kind of local belts and braces approach. So if we could move to the next slide, please, Renzo, in which I will talk about market research. So this relates to where a pharma is engaging an agency to provide research on patients or HCP's experiences with a product or the organization more generally. So it depends on the agency and the nature of the research as to what different types of data might be processed. Our general experience is that pseudonymous data tends to be used and processed. So that can be via hashed or masked research participant names or faces, kind of contact details. So often an agency might blur faces or distort voices in a recording as means of providing the findings to the sponsor. And as a reminder, that pseudonymous data is subject to GDPR and will likely include special category data and the accompanying compliance obligations. So how do you determine the role of the agency? Well, you look at 3 key factors, and these are informed by our experience rather than official guidance. So 1, sample, 2, data collection methodology, and 3, reporting or project outputs. So these factors should be considered in the round, but sample is probably the most important one, since it goes to the heart of the purposes of the processing rather than the means. In the main, a pharma or a CRO will likely want the agency to be just a processor for compliance purposes, but the role does need to reflect the factual reality and expect pushback from the agency who might want to position themselves as a controller to use the data for their own purposes. So just some specific points to consider in each of these factors. So on sample, is the pharma providing a targeted list of research participants or narrow, highly specific criteria? Physicians specializing in X, located in geographic region Y, that's controller type behavior. On data collection methodology, who's specifying the software and technical means for collecting and processing the data? On reporting and project outputs, who's determining the means by which the report and project outputs are provided? So recordings, written reports, discussion transcripts, and the likes. And then finally, if you're still unsure after evaluating those 3 factors, there's some other considerations. So whether the agency retains the participants' data after the termination of the engagement, whether the agency engages other third-party service providers, in its own name or in the pharma's name, whether the pharma's representatives can observe interviews in person or remotely, and also whether the participants are actually aware that the pharma has commissioned a project. I know there's regulatory requirements around that. So I'll just wrap up there, just a kind of final point. So once you've determined the roles, you then need to do a lot of the things that I mentioned in relation to clinical trial projects. So terms, notices, contracts, and kind of take it from there. And I know there are some templates for this, particularly from the British Healthcare Business Intelligence Association. So I'll hand back over to Kirsten.
Michael, before we go on to Kirsten, one other question I'll pick up at this point, which is quite an interesting one. There's the EDPB guidance, which has come out recently, does touch upon controllership and processorship in the context of clinical trials. Now, you haven't got it, well, I assume, in front of you right now, and you may not know the detail, but I had a chance to look it up whilst you were talking. The question was, EDPB set out the possibility that an investigator, the site, might be a joint controller with the sponsor. And just to answer that question, the question is, what are our views on that? And I think in that particular example, and EDPB do talk about it, and this is an important part of determining whether someone is a controller or not. The site, the investigator, was involved in creating the clinical trial protocol. So the characterizations which we've given in this webinar, Michael's talked about just now, are for typical scenarios and typical examples, but it's always possible that even in a particular country where the relationship is as set out, there might be differences in the context of a particular trial. And as I say, that particular example in the draft EDPB guidance is one where the site was intimately involved in creation of the protocol with the sponsor.
Yeah,
yeah.
I'd just add kind of 2 supplemental points to that, Renzo. So one, yeah, that kind of goes to the general overarching point that these things are very kind of trial specific. So an evaluation needs to be kind of taken on each of their merits. And then secondly, so in the Netherlands, their kind of regulatory position is more often than not, it's kind of joint controllership. So not by all means a kind of new concept, but yeah, does kind of vary between countries.
Great, thank you. And over to Kirsten. And hopefully I'm moving the slide here. Yep.
Right. Thank you, Renzo. Yeah, so hot topic number 3 and data subject requests. So again, flagging a few key issues that we come across. So the basic point to make is that health data or special category to personal data that's processed as part of a clinical trial. The GDPR data subject rights do apply, and there's no general exemption around compliance with those rights because of the context of it being health data clinical trial or anything like that. And what we find is in practice that it can be difficult to comply with those data subject requests under the GDPR sometimes. And if you're relying on consent to process personal data, it can be particularly problematic. And the reason being is that the data subject has to be able to withdraw that consent, which in a clinical trial, you are required to retain certain data, and actually there might be other sort of health data processing reasons for collecting health data, and you might have legal obligations or other really good reasons for holding on to that data. And so if you've relied on consent to process personal data, it's going to really scupper those purposes for holding on to it. If someone says they no longer want you to hold their data and they withdraw their consent. Another key issue is, and this goes back to what Michael has been saying, is that it's really important to understand the roles of the parties and work through who's the controller, who's the processor, and you know, this may differ depending on the exact scenario, as Renzo just said, and it might also differ in terms of what's the typical practice, as Michael was saying, and different local ways of doing things in different countries in Europe. But having worked out who the controller is in a particular country, and that is the entity that's going to be responsible for complying with the GDPR and to respond to data subject requests. So one of the key things for controllers to watch out for is making sure that if they say if you're the sponsor and you only have coded data, you're getting the help from your processors or other controllers involved in responding to those data subject requests, which you still need to comply with. And as I said, consider local law variations as well in terms of how you proceed. There still is no harmonization across Europe, despite that the GDPR was supposed to bring that harmonization. So you might actually find that locally there are variances around and different exemptions that have been bolted on in terms of having to respond to data subject requests. So I'm going to talk you through a few examples. I've got 3 examples just to put this into practice. And the first example is a clinical trial patient exercises their right to be forgotten. Now, just to say, the right to be forgotten is actually a limited right in that the way it works is you have that right, but only in limited circumstances. And those circumstances are that the data is no longer necessary for the purpose for which it was collected. So in this clinical trial example, the data is still going to be needed. In fact, you're going to be subject to requirements to retain the data. So the data subject can't rely on that one. Consent is withdrawn and there's no other legal ground for processing. So as I said, if you're relying on consent as your lawful basis for processing, and then the data subject turns around and says, I'm withdrawing my consent, it can be difficult. But for this particular data subject right, the right to be forgotten, there is a little sort of get out of jail free card here, where it says, and there is no other legal ground for processing. So if the data subject withdraws their consent, you have to stop the processing unless there's actually another lawful basis for processing the data that you can rely on. And actually there most probably would be. They can also rely on this right if they are objecting to the processing carried out in the public interest or legitimate interest, and there's no other legal ground for processing. So this is where you've relied on either of those lawful basis, And again, there's no other legal ground for processing. So that's similar to the consent one, where in effect you would need to swap to another lawful basis for processing to be able to retain the information. They can also ask you to forget their data if you're processing it unlawfully. Well, that's very unlikely. And the data needs, or if the data needs to be erased to comply with a legal obligation. Well, actually, in a clinical trial context, it's quite the opposite, where you're needing to hold on to the data to comply with obligations. And this right can also be exercised if the data was collected in connection with information society services, but so that's not going to be relevant in a clinical trials situation. That's more to do with, say, you know, you've put your information out there on a sort of online social media platform. So moving on to example number 2. And these, by the way, are the sort of data. I'm just picking on a few data subject rights and the ones that are most likely to occur. So example 2 is that the patient in a clinical trial has asked the sponsor to access their personal data. Now, this right just applies, but subject to some very limited exceptions. And the only exception under the GDPR is that the request is manifestly unfounded or excessive. Now, as I said, it's worth checking the local law as well that's relevant, because there might be some other grounds that they've bolted on locally for not complying with an access request. And so, as I said, if you get one of these requests, you're very likely going to need to comply with it. Because there's very limited exceptions. So you need to make sure that you've got all of your arrangements in place with potentially other controllers involved in the trial, with all of your processors like your CRO, to make sure that even if you can't identify the individual and go and get that data for them, all of your partners that you're working with, they can help you with that. And another key point to mention is laboratories. Now, this is because when laboratories process the personal data, they may be holding on to that for a while and doing batch processing, but they can't actually identify the individuals. So they might be one of the partners involved, but they can't help you if the data subject has asked for data and it's held by the laboratory. And they might be holding on to that in a pseudonymized form for a length of time which extends beyond the time period during which you have to comply with a data subject request. So that's worth bearing in mind when you're using laboratories, and you know, what's the turnaround in terms of getting data back from them so that you can comply with these requests. So on to example number 3. So the sponsor relied on consent as a lawful basis for processing the personal data, but the patient has then come along subsequently and they've withdrawn that consent. So they're perfectly entitled to do that if you've given relied on consent. Now, as I said, this one is a problematic one, and you might well have an overriding legal obligation to retain the information in a clinical trial. And that means that you cannot actually comply with this GDPR obligation when someone withdraws their consent. So there's a juxtaposition there, which you may well fall foul of. So thank you, Renzo.
Okay, and before we go on, Michael, we're sort of overrunning a little bit. Forgive us, please, our audience, and we might need to speed up the next couple of hot topics, please, Michael.
Yeah, no problem at all. So hot topic 4, requirements around international transfers, and specifically the implications of the Court of Justice, the EU Schrems II judgment in mid-July. So as you'll likely be aware, the court passed judgment on the validity of the standard contractual clauses and the EU-US Privacy Shield as a means to legally export data from the EU to the US. Headline points: standard contractual clauses remain valid, but crucially there'll be some circumstances where the controller, so the exporting organisation, has to verify on a case-by-case basis the laws of the country in which the importer is based, to ensure that they're kind of compliant with the standard contractual clauses. If not, put in place additional safeguards to bring them up to standard contractual clause standards. Other key point, Privacy Shield was deemed invalid on the basis it doesn't ensure kind of adequate protection for the data. That was largely due to concerns around the US's surveillance regime. So what's happened since the judgment? Two important developments. European Data Protection Board has come out with FAQs stating that they'll be providing some hopefully much needed guidance on that verification process and additional safeguards. No date yet provided for that publication. Also explained no grace period from sanctions, but we're not aware of any enforcement actions so far. Second important development, European Commission's explained they'll be expediting their work on producing updated standard contractual clauses. Existing ones aren't fit for purpose, they're more than a decade old, non-compliant with the GDPR, so some much needed updates are in the pipeline, due to be published towards the end of this year or early next year, and we understand they're meant to be modular, so cover controller to controller, controller to processor, and also potentially processor to sub-processor and processor to controller. So one document instead of multiple documents, as the case at the moment. So what does all of this mean for pharmas and CROs? Well, if you've been relying upon Privacy Shield, you need to look for an alternative. And that covers any transfers involving your customers, vendors, or group companies. Alternative will likely be the standard contractual clauses, and consider which ones you need. So controller to controller, controller to processor, or both. So some mapping and kind of triage work to be done there. Second point is that you'll have notices, policies, contracts which make reference to Privacy Shield. Amends to those will be required in due course, but remember that the framework actually benefits from what's known as the kind of Hotel California protection, in that you can kind of check out, but you can never leave. So when the data has been transferred under the Privacy Shield, it still needs to be protected to those standards. So don't remove all of those references straight away. Third key point, consideration of the position around like verification process and additional safeguards. Similar to most organizations, you'll be thinking, what's that mean in practice? How are we meant to verify third country surveillance regimes? And what are the additional safeguards? There's technical, so encryption, contractual, so tighter clauses and policies. Those are potential ones. We await further guidance from the EDPB. And I'd say historically, pharmas and CROs might not be subject to surveillance as much as other organizations like telcos or technology companies. But in the current COVID context, might not necessarily be the case given the importance of health data. And then fourth implication, we're seeing a lot of, probably most importantly, a lot of confusion around how to use the standard contractual clauses. So for those kind of processor to controller transfers where they don't work, and we're covered under Privacy Shield, there's quite a lot of confusion about that. Difficult negotiations, especially when you look at what's in the SECs closely. There's fairly strict audit rights and sub-processor requirements. So typically we advise clients to kind of enter into controller to controller SECs and to amend these or kind of soften them to reflect the positioning. And then finally, we've noticed a trend towards a move to consent or public interest as a derogation to the data transfer requirements, and so obviate the need for SECs. Common because, as Kirsten mentioned, pharma space places such a focus on consent, but we'd recommend avoiding this for two main reasons. First, Kirsten's already talked about the drawbacks of consent, and secondly, consent and public interest are derogations, so they should only be used where you can't put in place standard contractual clauses. So fair amount of friction in international transfers at the moment, and the need for kind of creative solutions, at least until the updated SCCs arrive.
Thanks, Michael. One other question on this point, and I'll quickly answer it as well, if you forgive me. Someone asked a question about, but surely FISA doesn't apply to pharma, FISA being the law which was particularly scrutinised by the Schrems judgment and applies to electronic communication services companies, for those of you that don't know. Yes, FISA doesn't apply to farmers, but it will apply to technology companies that farmers use. At least that's our understanding. We're not US lawyers, so there the theoretical potential that the criticism that was levied in Schrems in relation to data in the US or indeed elsewhere does apply to data in the hands of pharma, but as Michael sort of alludes to, the risk, and that will be part of any risk assessment which will be undertaken in relation to a post-Schrems transfer assessment. The risk in relation to pharma data is going to be much smaller if than risk in relation to social media usage data or telecom usage data. Michael, we're rushing a bit, but never mind. Let's move on to Kirsten, please.
Right, thank you. So to give you an overview of what's been going on in the healthcare sector from a security and enforcement perspective, so I found this interesting statement in Verizon's 2020 data breach investigations report, which I thought summed it up very nicely, where they said essentially financially motivated criminal groups continue to target this industry via ransomware attacks. Well, I would say actually, I think that's it's not just the healthcare sector that's been targeted by ransomware attacks, particularly in recent times. Lost and stolen assets also remain a problem in our incident data set. So they're talking about things like lost laptops, for example, containing health data. Basic human error is alive and well in this vertical, and misdelivery grabbed the top spot among error action types. So now this happens regardless of the sector all the time. This is the misdirected email blooper, for example. But when you're working with health data, of course, the stakes are much higher because you might potentially be sending some quite sensitive information to the wrong recipient. And as they've flagged here, this is still something that's going on quite a lot. And they've also flagged the internal misuse has decreased, but it's still happening. In fact, there was a case in Europe, a GDPR enforcement case, which involved the access controls that were set by a healthcare provider. They set them too widely, and too many people could get in to see data that they shouldn't be able to see. And there'd been a famous person staying at this health centre, and lots of people have gone and accessed the records. And the organisation was fined for that. On to the next slide, please, Renzo. So just to give you some general thoughts on enforcement under the GDPR, it hasn't actually been prolific, I don't think you can say. It started off very slowly in the early days, so when the GDPR came in 2018, certainly for the first year. Then we started to see an increase in activity in terms of fining, and then there's been a slight drop off during the pandemic. We haven't seen particularly that health data handling organisations are singled out by regulators, so not more so than other sectors, but we are seeing some enforcement action in this sector, and particularly from the regulators in France, Germany, Greece, Hungary, the Netherlands, Romania, and the UK. And actually, the Netherlands tends to be at the higher end of the scale in terms of imposing fines in this sector, and Romania and Hungary are more subscribing to the little but often style of fining. And then just a note on the pandemic. So we saw that fines generally across the board, all sectors, they slowed down a little bit, or other enforcement action, when the pandemic kicked off. We're now seeing, the brakes were on, the brakes are now coming off again. We're seeing regulators starting to fine again. And actually, we very recently saw British Airways in the UK. They were fined by the Information Commissioner's Office. And there was a slight reduction in the fine because of the influence of the pandemic and the changed situation that they find themselves in. But it was actually only £4 million. The Information Commissioner had said previously they'd intended to fine British Airways £183.39 million. That's now been reduced to 20 million, so quite a significant reduction, but only 4 million of that was related to the pandemic, they said.
Thank you, Kirsten. Thank you, Kirsten. Sorry to cut you off there. I'm conscious of time, and I want to just take one more question, Kirsten, because you haven't had a chance to answer one yet, which is in relation, going back to your hot topic on access rights. What do we think about inserting a caveat in a privacy notice for either blinded or double-blinded trials? There's a caveat. Can you notify your way out of the access rights?
Depends on what's meant by having a caveat in the. Is that like an exclusion of liability type of?
That's all I know. That's all I know. I'm assuming that the question is asked.
So if actually what you're trying to do is sort of have some sort of disclaimer in your privacy notice, then no, that probably wouldn't go down too well with the regulators in terms of. So really what you need to be doing from an access rights perspective is making sure that you are setting up all of the technical and organizational controls internally on all of your systems, and all of your processes are doing the same to make sure that absolutely only those people that need access to personal data have access to that data.
Great. Thank you very much, Kirsten, and apologies everyone that we rushed a little bit at the end there, but thank you all for joining us. I do hope it was helpful and gives you some of the answers you were looking for. We didn't get a chance to answer all the questions, but we'll follow up by email in the next week or two. We will send slides, a link to the recording very soon. As I mentioned at the outset, we do have webinars, every 2 weeks or so, sometimes a little more frequently, sometimes less so. Actually, our next webinar is next week, led by our partner Leonie Power, and that's going to be on the latest EDPB guidance, including that which is mentioned in one of the earlier questions on processor controller, but also on social media guidance, and we have others coming up towards the end of the year. So if you're interested and haven't received an invitation for next week's one, then please do get in touch, and thank you very much once again for joining. Bye-bye.